IRCTC Tatkal scam. Paying without traveling. Why this is unconstitutional, PIL explained. Have you ever booked a Tatkal ticket? Didn't get confirmed. Didn't travel. And still lost money. This is not just frustration. This is not just inconvenience. This may be unconstitutional. Today, I will show you how passengers are losing money without any travel, why this practice is legally questionable, and why this issue affects lakhs of Indians every year. I deposited Rs 3,100 in my IRCTC wallet. I booked a 3A Tatkal ticket. Base fare shown Rs 2,970. Convenience fee Rs 35.40. Total charged Rs 3,005.85. After booking, my wallet balance became Rs 82.35. But wait, Rs 3,100 minus Rs 3,005.85 equals Rs 94.15. So, Rs 11.80 disappeared immediately. Now listen carefully. The ticket was waitlisted. It never got confirmed. I never traveled. After chart preparation, IRCTC said Rs 2,905.36 will be refunded in 3 to 4 days. That means Rs 100.49 deducted officially. Rs 11.80 already missing. Total loss equals Rs 112.29. For zero travel. For zero seat. For zero service. Now think bigger. If one passenger loses Rs 100 and lakhs of passengers face Tatkal non-confirmation every year, this becomes crores of rupees collected without transporting anyone. An ordinary citizen cannot book again and again till confirmation. This system punishes urgency and poverty. Let's ask one simple question. What is the service railways is legally authorized to provide? The answer is simple. Transport. Not a chance. A probability. A priority attempt. Until a seat or berth is allotted, transport service does not begin. So how can money be retained when no transport ever happened?
Tatkal is a priority service. Even unallotted passengers got an opportunity.
A chance is not a service. Railways is not a lottery authority. You cannot charge citizens for probability instead of transport.
Policy is disclosed. Passenger consented.
Consent cannot legalize arbitrariness. Courts have repeatedly held disclosure does not cure unconstitutionality. You cannot take money unfairly just because it was written in fine print.
Administrative and system costs justify retention.
Actual cost per failed Tatkal booking is minimal. Blanket deduction of premium is disproportionate, excessive, unjust enrichment. If costs exist, deduct only actual cost, not the full premium.
Tatkal managers demand.
Demand management cannot mean forfeiture without service. Under the doctrine of proportionality, the burden on citizens must be strictly necessary, not excessive. This practice violates Article 14, arbitrary and unequal treatment. Normal whitelisted passengers get full refund. Tatkal whitelisted passengers get penalized, despite both getting zero service. Unjust enrichment. The state keeps money without providing transport. Consumer Protection Act, 2019. No service rendered equals deficiency. Indian Contract Act, Section 65. When consideration fails, money must be restored. This is not about one person. This affects daily wage workers, emergency travelers, students, senior citizens. Individual loss is small, but collective injustice is massive. That is why this issue qualifies for a public interest litigation under Article 226. We are not asking for free rides. We are asking for fairness. Full refund when no seat is allotted. Chance does not equal service.
Call to action. If you have lost money on unconfirmed Tatkal tickets, felt cheated but stayed silent, believe nothing can be done, this video is for you. If you feel this is not a serious issue, ignore this video. If you feel the same unfairness, share this video, comment with your experience, tag railways, IRCTC, MPs, and journalists. Support a PIL demanding fairness. When lakhs speak together, courts listen. Tatkal was meant to help urgency, not exploit it. Transport is the service. Without transport, there must be a refund. Justice is not free, but injustice should never be profitable. Thank you.
In the Honorable Court of India, writ petition public interest litigation. Under Article 226 of the Constitution of India, in the matter of arbitrary, unreasonable, and disproportionate retention of Tatkal charges and clerkage by Indian Railways in cases where passengers are unable to travel due to non-allotment of seats, resulting in retention of money without provision of transport service. Between citizens of India, residents of India, public-spirited citizens acting bona fide in public interest, versus 1. Union of India, through the Secretary, Ministry of Railways, Rail Bhavan, New Delhi. 2. Indian Railway Catering and Tourism Corporation Limited, IRCTC, through its Chairman and Managing Director, New Delhi. Writ petition under Article 226. A. Locus standi of the petitioners. 1. The petitioners are public-spirited citizens with no personal or private interest in the present litigation. 2. The issue affects lakhs of railway passengers daily who book Tatkal tickets and are unable to travel due to non-confirmation. 3. Individual litigation is impractical due to small individual monetary loss per passenger and massive collective financial impact nationwide. 4. The matter therefore squarely falls within the scope of public interest litigation. B. Facts of the case. 1. Indian Railways offers a Tatkal quota, charging a premium over normal fare for urgent travel. 2. If a Tatkal ticket remains waitlisted and unconfirmed after chart preparation, no seat or berth is allotted, the passenger does not travel. The transport service never commences. 3. Despite the absence of any transport service, the respondents retain the Tatkal premium. D. The clerkage and convenience fees. Refund only a part of the base fare. 4. In contrast, passengers booking under normal quota, whose tickets remain waitlisted after chart preparation, also do not travel and receive full fare refund subject only to nominal clerkage. 5. The respondents justify retention of Tatkal charges and clerkage on the ground that Tatkal provides priority access or opportunity to book, even when no seat is ultimately allotted. C. Questions of law. A. Whether retention of Tatkal premium and clerkage when no seat is allotted violates Article 14 as arbitrary and unreasonable state action. B. Whether chance, priority access, or opportunity can be legally treated as a service in the absence of actual transport. C. Whether retention of money without commencement of transport service amounts to unjust enrichment by the state. D. Whether blanket deduction of Tatkal charges and clerkage satisfies the doctrine of proportionality. E. Whether administrative or system processing acts alone can justify monetary forfeiture when the core service, transport, never commences. D. Grounds. Ground 1. Violation of Article 14 arbitrariness and unequal treatment. 1. Indian Railways as state under Article 12 and is bound by Article 14. 2. Two classes of passengers. Normal quota waitlisted passengers, full refund subject to nominal clerkage. Tatkal waitlisted passengers, partial refund with forfeiture of premium and clerkage. 3. Both classes receive zero transport service. Do not travel. 4. Differential treatment without rational nexus to service rendered is manifestly arbitrary and violates Article 14. Ground 2. Transport as the service, not a chance. 1. Railways are statutorily authorized to provide transport, not speculative chances. 2. Until a seat or berth is allotted, transport service does not commence. No passenger carriage occurs. 3. Administrative acts such as accepting booking requests, processing payments, granting priority access do not constitute transport service. 4. Tatkal is not a lottery, and the state cannot charge citizens for mere probability. Ground 3. Unjust enrichment through retention of Tatkal premium. 1. Tatkal premium is charged solely for urgency of travel, not for attempting to book. 2. Where no seat is allotted, urgent travel does not occur. The purpose of Tatkal premium fails. 3. Retention of Tatkal premium without transport results in unjust enrichment, impermissible under constitutional and common law principles. Ground 4. Arbitrary and unreasonable deduction of clerkage. 1. Clerkage is justified historically as a processing fee, not as consideration for transport. 2. In modern online booking systems, booking, waitlisting, and refund processes are largely automated. Marginal administrative cost per unconfirmed ticket is negligible. 3. Deduction of clerkage when no seat is allotted and no transport service commences lacks proportionality to any actual cost incurred. 4. Blanket clerkage deduction without cost disclosure, cost justification constitutes arbitrary state action under Article 14. Ground 5. Failure of the doctrine of proportionality. 1. Demand management is a legitimate objective. 2. However, forfeiture of Tatkal premium in clerkage when zero transport service is rendered is excessive and disproportionate. 3. Less restrictive alternatives exist. Full refund when no seat is allotted. Nominal cost-based processing fee. Capped or slab-based deductions. 4. The present policy fails the proportionality test. Ground 6. Unreasonableness of state commercial action. 1. When the state engages in commercial activity, it must act fairly, transparently, non-exploitatively. 2. Charging premium and fees without providing transport converts a public utility into a revenue extractive mechanism. 3. Such conduct is contrary to constitutional morality and public trust. Statutory support. 1. Consumer Protection Act, 2019 Section 242. Service requires actual service rendered. Non-allotment of seat equals service not commenced, pointing deficiency. 2. Indian Contract Act, 1872 Section 65. When consideration fails, the benefit received must be restored. Preemptive rebuttal. 1. Tatkal is a priority service, pointing priority does not equal transport service. 2. Policy is disclosed and consented, pointing disclosure cannot validate unconstitutional arbitrariness. 3. Administrative and system costs justify deductions, pointing actual costs must be minimal, disclosed, and proportionate. 4. Revenue protection must use risk, pointing minimal cap deductions suffice. 5. Policy domain judicial restraint, pointing courts must intervene where policy results in manifest arbitrariness and unjust enrichment. Prayers. The petitioners respectfully pray that this honorable court may be pleased to a. Issue a writ of mandamus directing full refund of fare including Tatkal premium, where no seat berth is allotted, or in the alternative. B. Permit only minimal cost-based deductions, duly disclosed and justified. C. Declare that chance or priority access does not constitute service in the absence of transport. D. Direct respondents to disclose actual administrative costs, forming the basis of any deductions. E. Review and rationalize the policy of clerkage deduction for unconfirmed tickets. F. Pass any other order deemed fit in the interest of justice. H. Interim relief, cap forfeiture amounts pending final adjudication. Direct maintenance of a separate account for Tatkal forfeiture collections. Affidavit. The petitioners affirm that this petition is bona fide. No personal gain is sought. The matter concerns public interest. Filed by Petitioners Council. Place, India. Date, today.